door. My daughter had hit me at the time, and I knew she was there. I did not stop in any time. Motion never hit my child. I have 7 children that I'm involved with every single day, raised, and even my other 3 that I don't get to see, I still see them every weekend. But again, I'm not a violent person towards my kids.
So Layla lied to the police?
I believe it was a lie. She's had issues with that in the past. She's 9. Not with issues in this situation, but lying. I think she was scared. I don't know, but I know that I never tried.
Right out of the gate, he frames himself as the victim. Notice that shift? When someone accused of violence immediately emphasizes what was done to them, that's often a minimization tactic. But here's the key question for you. Is this self-defense or deflection?
I need the hands on my child.
The court says that she pushed you, trying to get you off of her mother, then you turned and punched her in the stomach, and she told the police that she had stomach pain after being punched by you.
I know that I did not turn and hit my child. I think that she was scared. I did not hit my child, Judge. I know that for a fact. She didn't push me. I was pulling her out the door. I had the door open, and she was hitting me in the side of my head and face, which I got that look from her. But I did not ever stop at any point to hit my child. The investigation was she did that. She was lying through an investigator because she wanted me to be in trouble for her and her mother fighting. She felt that I needed to be in trouble for her.
So was Jessica lying when you said that you choked her out?
She's 9. That's the detail that changes the temperature in the room. In domestic cases involving children, courts tread extremely carefully. Accusing a child of fabricating a violent allegation is serious, but so is the allegation itself. Who has more credibility here? And what motive would a 9-year-old really have?
I don't think I choked her out, Judge. I did grab her. I even told the officers as well. I did grab her by the neck and her coat that she had on and drug her out. I didn't choke her. Choking her, I don't know. But I did grab her by her neck and her jacket, the side of the arm, and yanked her and drug her out to the door.
The court says that you put 2 hands around her neck and choked her for about a minute.
That to be true, Judge. I was drinking, like I said, but I don't. I just grabbed, pulled out, moved her out. I obviously maybe choked her while that was occurring, but I didn't choke her.
You dragged her out of her house like somebody would drag a dog out of her house. You need to go outside, right?
That sounds like a lovely way to just pull her outside.
Dragged her out like a dog. No? Okay. All right. Ms. Robinson, any additions, corrections, or challenges?
No, Your Honor.
Anything that you want the court to consider?
Your Honor, I'd like the court to consider that the 12-month cap was offered by our office. The recommendation from the agent was prison. People are sticking with that.
And there it is, the pivot. We move from the child allegation straight into the choking allegation. In court, choking is huge. Legally, strangulation is considered one of the strongest predictors of future lethal violence. Judges don't brush past that. This is where things get very real.
Offer because of the statements we have had from the victim since. So I would ask the court to sentence pursuant to the offer that we made. However, I would ask the court to maximize the amount of time that he gets here so that when he's out, if he violates again, prison is all that is left. I think it is important to note that the minimization here leads me to believe that all of the work that is being done is simply for the purpose of looking good to the court and trying to avoid jail time. It doesn't actually seem to be anything genuine by the defendant. He just, every question, minimized what happened. He said he just took her outside. Ms. Frost indicated to the officer that When he dragged her outside, he body slammed her so hard onto the porch that she urinated herself. The fact that his daughter, who he claims was punching him, but he put no hands on, felt the need to intervene as he was attacking her mother, I find that to be problematic. We have heard from the victim. She has indicated that she wants all of this dropped. She doesn't remember it and makes a point of telling our office that she can't afford to live without the defendant, that he pays the bills. I believe that this is a family that is in a situation where the fact that he is the provider is leaving them in a...
Listen carefully to the language. I didn't choke her. I grabbed her neck. That distinction might feel semantic, but in a courtroom, it's everything. If your hands are around someone's neck for up to a minute, most courts are going to call that choking, regardless of intent. Do you think this is memory fog from drinking or minimizing again?
State of needing to be controlled, even in the last 2 minutes where you questioned him. I know you heard this, but you asked him what kind of person chokes someone out. He said, oh, someone not in a good place who's drinking. And then later when you said you choked her, so that's what it said, he said, well, I don't really think that happened. So I would ask the court to sentence pursuant to the offer that was made. We will dismiss the new charges as we said we would, but I would ask the court to consider all of that when deciding how much of this time he should serve and before making any decisions about the no contact order. Thank you, Your Honor.
One question for you.
Yes, Your Honor.
Both of you. The 2024 domestic and district court here on the PSI, it shows it was pending with the sentencing date of March. Did he end up pleading to that? Was he sentenced on the domestic district court?
That detail, she urinated herself, that's not minor force. That suggests extreme impact and trauma. And here's what prosecutors are subtly arguing. This isn't just about one bad night. It's about control, dependency, and a pattern. When the victim says she can't afford to lose him because he pays the bills, that's not reconciliation. That's leverage.
I'll recall he's on probation. 6 months. Yeah, he thinks he may have been on probation on that one.
6 months of probation in the district.
6 months of probation in the district.
And was the victim in that case Ms. Frost as well?
I believe she's here today.
Your Honor,
Yes.
my notes indicate that there was a deferred sentence on the misdemeanor domestic violence in the district court here.
Okay. Did he successfully completed the deferral?
It appears so because he was discharged from probation successfully on September 26th of 2025, Your Honor.
All right, the PSI says he's got 90 days credit, rated 2 days. Obviously, filed originally 2 days, then sentenced to serve 87 days with 87 days credit, and he served 3 days for posted bond on this probation violation. Does that sound right, Mr. Watkins? You served 87 days in jail?
Yes, sir.
Judgment sentence says you served 45 days and 11 days credit, and you served 45 days. Over 45 days, 11 credit, you had 34 to serve.
Are you talking about the underlying charge, Judge?
Yes.
Yeah, I think that. All right. So what had happened in that case, from what I recall, is that he bonded out, but probation thought he was still in jail. He bonded out, so that they had it 90 days
Okay.
of him
So
serving. Where
so you
he,
served 45.
I think that's the number. Judge.
Okay.
Now comes the moment that decides everything. Sentencing. The guidelines say 0 to 11 months. The plea deal caps it at 12. The judge has discretion. And here's what judges look for more than anything: accountability. Not excuses, not maybe, not I don't recall. So ask yourself, has he truly accepted responsibility, or is he still negotiating with reality?
That's what we had as a credit for 48. All right, the court recognizes that the advisory guidelines in this case would suggest a sentence between 0 and 11 months, the courts can exercise my discretion, sentence consistent with the advisory guidelines, consistent with the agreement in this case. Would be the sentence of the court. This defendant served 7 months in the Laredo County Jail. I'll give him credit for the 48 days that he's served so far. Is going to be continued on probation with the same terms and conditions as was originally imposed. Mr. Watkins, the court probably would have given you the 11 months or a year, but you have been, I'll use the term generously, you've been working on some issues. I don't know if you've been going through the motions or if you've been actually working on the issues, but at least you're trying. You got a long ways to go. You can tell from my court's questioning and dissatisfaction with your answers, you still haven't internalized what you did, I don't think. But you spent a fair amount of money, you're trying to do the right thing, so that's the only reason that you're getting 7 months and not a year.
Comment your opinion, like the video, and subscribe for more real courtroom moments.